Okay, we're here for the final debate. Here it is, 303 LLC versus Elenis. We are going to decide by a coin toss of who's taking what side. If I had a coin, one thing I was not prepared.
I got one.
You got one, Jalen.
I got one. We did.
Yeah, you can pick heads or tails, and then you can decide if you want pro or. But I'm gonna flip, make sure that you don't swing that in favor. There you go.
Here we go.
Okay, all right. Now, what is Jalen's coin? Call it his tails.
No.
What is it? It's tails. All right, Steve. Which one? What side do you want to take? Pro or con? Although this seems a little more fair since there's a lot less people on this. Team 2, do you want to be 303 LLC or would you like to be Elenis? You're gonna be 303. That means you're the petitioner, so you will get to go first.
303 LLC.
303 LLC
Versus Elenis.
So you guys are gonna be representing Elenis and making your oral argument after, making your argument after. So all the rules from the debate, you have a total of 30 minutes. You get one main argument and one rebuttal. Do you know how you would like to divide up your time?
That's a great question. I have no great questions like that.
So I will say typically, if I was in a closing argument and I was a prosecutor and I was allotted 30 minutes, I would take 18 for my main argument and 12 for my rebuttal with the right to encroach.
Yeah, that's what I was thinking too.
All right.
That's
So here's what will happen. I will time you for 18 minutes. I will hold up when you have 5 minutes left. I will hold up when you have 2 minutes left, 1 minute left, and then I will let you stop. If you continue to go past that, it will encroach on the time for your rebuttal. Having heard that, you understand the rules for when you guys go next. You will have however long you want. If you want it to be 20 and 10, 15 and 15, all your choice. You can take some time to think about that. I would also listen to what they're saying. Probably say most of what they're saying for your rebuttal because they're going to be listening to you and responding to that rebuttal. Rebuttal should really be about responding to what the others have said, not so much about rehashing your argument, okay? So just kind of give you guys a little heads up in advance. If you go over your original allotment, you decide you want 18 minutes as well, and you end up doing 20, you will only get 10 to your rebuttal. So no one gets more than 30 minutes. Point blank period.
Yes, you are.
Yes, Your Honor. Does anyone have any questions before we get started? Yes, Emily.
During our time, do we need to split up what we're saying between our members, or can just one person speak through the whole?
You guys, somebody at the door. You guys, oh, fine, excellent. There's teammates. Frank, point your team. They have elected to be 303. That's what I did in arguing. You guys are going first. I'll give you a few minutes to get it done.
More fun, isn't it?
So,
More fun.
okay, we have an idea what were my original intention was to talk during the first one, to do a little bit. And then if you want to elect one person to answer like my questions, but I interrupt your argument with questions, one person to answer or one person to rebuttal, and I'm very fine with that.
But everyone has to talk first.
Very initial one. Or if they make it clear that they're interested, like somebody doesn't actually talk about it. I should at least see that you're communicating at some point and you're not just sitting there staring back while we're doing the first one, right? I know it is. Anyone have any questions? Before we get started.
Let's open the cup.
Cupcakes will open after because we have plenty of time left after. I'll have one back. Unless Jay would like you to have it now, which seems like it might be hard for you to argue with your mouth full, but a Barbie is for me to stop you. Okay. Pulling up my timer. All right. So you guys want 18 to start?
You guys are gonna do one.
We're ready?
For you.
As soon as you tell me you're ready, I will press start. I will let you begin your argument. You will have 18 minutes. I will again give you your warnings.
Are we quiet?
Yes, the other team will be quiet. They will not interrupt.
This is not a presidential debate.
No, I will interrupt if I will.
Are we allowed to ask questions after they've done their part?
Yes, Emily.
Are we allowed to do like research while we're here? Yeah.
I will allow that, yes. Since you all have laptops. I will allow you that. I will allow you to do that. In any normal debate, that would not be permitted, but since it seems that both teams have devices capable of doing so, then it's.
He spotted the customers. No Tucker, too much sugar.
All right. Whenever we're ready. Are we ready? I'm doing right.
So you'll be doing, can I watch it or watch it?
If you log in on time. Sometimes it is.
Okay, because I'm still learning.
All right, team shoots. Are we ready?
So okay, ready to start.
Ready? All right, team shoots, and go.
Okay, Your Honor, my client, Lorraine Smith, is a website designer for, Gallery Creative LLC. And she wants to expand her website to include, that she created design for, wedding websites. Also, she wants to mention that she will not include LGBTQ plus clients, in creating website for their wedding because it goes against her religious belief. She believed that the state of Colorado Anti-Discrimination Act will prosecute her for having those beliefs mentioned on her website instead of risking a chance of them coming at her first. She would like for you to overturn the 10-court circuit where they mentioned that they do not believe that her beliefs of not wanting to create websites designed for LGBTQ clients on weddings. Any other business needs or things like that, she will allow LGBTQ plus clients, but when it comes to wedding design, she doesn't want to create websites for them based on her background belief.
So your client creates specifically internet content? Is it creates a lot of party planning? What specifically does your
She
client?
do different events, but she hadn't started with website design, but she wanted to venture into that field. So when before she created before she included, she would like to include that with creating website design for weddings. She doesn't want to have LGBTQ plus
Understood.
Because she goes against her belief.
because her religion, Christian religion.
Understood. And she's seeking in this particular case an injunction. Has she had client, is she being sued actively now by a couple, or is this trying to get ahead of?
She's trying to get ahead of the Colorado Anti-Discrimination.
Even though Ms. Smith has not yet started offering wedding websites,
Okay, although she hasn't started offering it, she wants to. And her business already serves to service causes and organizations she supports that already align with her beliefs. She does websites for veterans, animal welfare causes, and church mission organizations. Ms. Smith decides which commissions she accepts based on what the message is, not who's requesting it. She has already designed graphics and created websites of both religious and non-religious groups advocating for the causes that do align with her religious beliefs, regardless of the requester's identity. She is arguing that the Colorado Anti-Discrimination Act is violating the First Amendment right of free speech. The state of Colorado is forcing Ms. Smith to create speech, not just sell it.
How is this forcing her to create speech if she is a business and has opened up her platform? No one is, are you alleging that by saying that she has to abide by the laws of the state, that she is speaking for that? And if that's the case, would we venture to say that every business person who creates content for someone else is necessarily speaking on their behalf?
Ms. Smith is arguing that this is her artistic outlet. And she's considered it her God-given abilities. And she really wants to make sure that all her content aligns with her beliefs. Not so that she wants to go against the law, but she's arguing this as a hypothetical. This is all a hypothetical case because she has not started offering it yet. But she wants to avoid having a problem in the future. And she really does believe that this is violating her rights because this is custom artwork that she's creating customly for her clients.
So then the objection or the injunction she seems to have doesn't seem so much that you're asking the courts to not enforce the law, but to seek declaratory judgment that she is almost in a religious exception to that. Am I understanding the argument correctly?
Yes, the First Amendment grants us right of religion and freedom of expression.
And this is similar to any case that the Supreme Court has taken up before.
Yes, actually, there was a case, Herbie versus Lib, and Lib was a LGBTQ community that wanted to parade with I wanted to parade, but it was struck down, and the court ruled in favor of actually Herbie, so saying that speakers have the right to choose the content of their speech, especially in a controversial matter.
And do we consider weddings to be within that controversial matter? What would be the argument that a wedding is a controversial matter if it's government enforced? Remember, I'm not trying to challenge you or find a correct or wrong answer. I'm just trying to think of what the Supreme Court might argue or what they might argue.
I believe that it necessarily challenges a person's beliefs, and very controversial that enough to where it challenges a person's beliefs, basically.
Is it controversial if us as the Supreme Court has decided that gay marriage, LGBTQIA marriage, for whatever reason is constitutional? Would we then be denying them due process or equal protection of said law if we said that because it conflicts with your personal religious beliefs that we're going to shut down or you don't have an option to discuss this?
Ms. Smith is not attacking LGBTQ couples that want to get married. It is again just aligning with their beliefs. And to this, we could argue, again, gay marriage is not illegal, it's legal. But should a Muslim artist be forced to draw an image of Islam? Should Jewish artists be forced to create art that they consider to be anti-Semitic? Should a Democratic political firm be forced to take on a Republican client? It's about the fundamental principle of it.
A fundamental principle of forcing speech that someone would not otherwise endorse. Is that your argument?
Yes.
Examples, it's like the ADF website, the men's defendant freedom, which Lori Smith, the client, is partnering up with. The website itself raises some very valid questions, similar to the questions that she asked can the government force a Democratic speech writer to write speeches promoting the Republican Party? Or can the government force an atheist to sing at a church's Easter service? And really the answer here is no, the government cannot force the American people to promote views that they simply disagree with. Absolutely. Lois Smith, as a Christian woman, she follows the rules of the Bible and takes steps to live a sin-free life. And Smith knows that if she were to lead a sinful life, she would suffer. And you know, in the Bible, Romans chapter 6, verse 23 says, "For the wages of sin is death, but the free gift of God is eternal life." In John chapter 3, verse 16, it says, "For God so loved the world that he gave his own son, that whoever believes in him shall not perish, but have eternal life." And Lois Smith, the client, designed her website within these Christian values. And as an American, she has the freedom of speech to say who she would and would not like to serve. And she would have the freedom of religion to back her claim. Would you rather her risk her soul by taking the voice?
And my question to that would be, does that mean that her religious right is more important than the right of another to get married?
Her rights should be on the same level as everyone else's. One shouldn't be over the others, but right now she wants to do what she pleases, that falls under within these rights of freedom of speech. She would like to say what she would like to say, saying that if a gay person wanted to get married, they would have that. She just wants her rights just like everybody else.
But her right is coming at the cost of someone else's, is it not?
The people that wanted to work with her site would still be able to get that from someone else. She doesn't want to conflict with her own values inside.
So your argument is that another provider can do this just as well. And not violate. And she wouldn't have to violate her own feelings of immorality on with respect to this issue.
Absolutely.
And have there been any other kinds of times in which it's come into question, or is this the only group that she's refused to create, or is saying that she will refuse to create artwork for? Because if we follow other Christian tenets in the Bible, that would exclude several other members, and then we may be running afoul of any more constitutional violations. So I understand that she's seeking what seems to be declaratory relief in that she wants someone to tell us that she's not in violation of the law. How can I in advance tell you you're not in violation of the law if I have not yet seen how many clients or which clients you're going to refuse? And without knowing the particulars of their case, or how it violates her particular religious beliefs. Let's say I believe this with respect to LGBTQ, but the anti-Colorado anti-discrimination laws go much further than that. They have to do with race, issues of nationality, issues of origin. Is she also seeking a declaratory relief that if those also violate her religious beliefs, that she doesn't have to provide a website for them as well?
Well, luckily in this situation, our client, Lori Smith, it only pertains to those who are part of the LGBTQIA+ community, and that's the only certain group that she would rather not have within her service because of her religious values. She hasn't claimed yet that she wants to have the same feeling, same situation with those who are a certain race or a certain disability. Or
What about another religion? What if a Jewish couple wanted to use the website services for an Islamic couple? Facing the same, and each of those are facing the same rights to freedom of expression of religion. How would she then respond to that situation? Because again, if we're trying to seek a declaratory relief before a situation even happens, she's specifically requesting us to opine on one group, which does seem very targeted. So how can we, or how does she anticipate running afoul of those which will violate her same religious principles? Asking someone to put on, what is the difference between asking someone to put on LGBTQIA wedding information and the difference between asking them to put on a Jewish wedding information? What's the difference for your client? Because both of those would be inherent, it seems to be inherently problematic with her religious beliefs.
Ms. Smith has worked with a variety of people, regardless of their religious beliefs and backgrounds, race, etc. She does have reviews on her website, and you can tell by the names and last names that it's a variety of people with different background and race. She has blatantly stated that she does not discriminate based on race. She argued that it's relevant to this specific case. And her website just states that because of her faith, she is careful to avoid communicating ideas or messages that are inconsistent with my beliefs. She's not really attacking anybody because of her beliefs, she just doesn't want to do that. And again, reiterating the comment from earlier, Ms. Smith already only accept commissions that she is, based on what the message is, not who the requester is. So she'd already stated that and given that to the clients.
How many people has she turned away? For whatever. Do you have any known circumstances of kind of who she turned away or who might have been turned away by her client? Other than people who are in the LGBT. Specifically, do you have any instances where she refuses to, or is she requesting to also have a religious exemption? So that if there are other religions that ask to promote the same message, she doesn't have to, but she also going to seek that as well. Since that would, per your argument, violate her Christian beliefs and making her create Jewish, Islamic, or even atheist speech. Why not seek the exemption for the same reason if, as you say, it's not intended to be discriminatory?
I guess it's not more so about like who she has turned away, I mean, because she didn't come forward with information about who she has turned away, because he's seeking justice before it happens. So we really don't have very much knowledge or background on who she has turned away, because the portion of the website that she talked about, she hadn't created it.
So how is this not a moot point if we have not yet had any harm? There hasn't been a client that has been rejected and she hasn't been in a position to turn them away. How do we even have a justiciable case? How does she have standing to argue this? Or to ask this of us?
She feared that the state of Colorado will, when she do receive the habits on her website, she believes that the state of Colorado will prosecute her for violating the Colorado Anti-Discrimination Act.
It's very understandable. Our standard for deciding whether or not a case is moot or whether or not a case is justiciable is though if this is capable of repetition but evading review. How is it capable of repetition but evades review? Why can't we just wait until someone actually does sue her or she is prosecuted for violating the law? How do we even get into court if she has not yet had any negative outcomes by which to need justice?
Ms. Smith's case is to avoid that. She shouldn't be penalized for her disbeliefs. She shouldn't have to sit around and wait for the state to attack her or a client to sue her because she's already stated her beliefs on the website.
Is there any argument that there will be harm to her if we were to rule against her?
Would just be a setback to the community, Christian community who just want what they believe to really be shown and just be respected and stuff like that. So it would be like maybe a slight hit to the community that she's a part of.
Will she suffer any personal consequences if we do not move in this way and she proceeds forward with her business as intended?
A personal consequence could be, it could limit her financial income, although this would bring more,
Doesn't she do that herself by refusing certain clients?
she does. She wants to expand her business and then the state declining this motion would limit her. And as she wants to expand it, this would constrict her financially.
You're at 17 minutes. Ms. Neal just wanted the board to clarify, you know, when businesses are engaging in expressive activities, that they are entitled to, you know, their First Amendment right, with religious-based exemption from certain laws protecting her civil rights.
So this is essentially a declaratory action asking to protect her due process and equal protection rights as a Christian in the event that she proceeds forward with her business plan. All right, anything else you want to say before your time's up? And again, you can still have a full 12 minutes for a vote.
And I feel like necessarily that, this case is right enough, because according to, early, you guys have already decided that the state has no right to limit a person's right of speech. It's right.
It's right because the law exists and because she's trying to make the speech.
Yeah.
That's right. Thank you so much. Anything else? All right, we're gonna pause there for now. You're at 19 minutes, so we will have 11 more minutes for your public. Yes, Ms. Emily,
If we ask for time to prepare, does that take over our time?
do you want a few minutes to regroup right now?
Yes.
Take it. You can have like 2 minutes.
Looked up the case and there, it's like. What would you consider a record?
Otherwise, I'm gonna put them just fine. You know, you guys are freaking. That means straightforward. Does just sit and push. We'll do the same thing.
With all this, warrants would consider that to.
If they're voting in the opinion, they're all referenced.
I mean, some of them, like the ACLU had some stuff, the American Bar, this report, that's their side,
Still.
and, any daughter.
Absolutely.
I think it's in League of Women's Voters. I would think more related, organizations would be. So basically, her defense attorney. It's gonna be a very. One of those cases that we did, what got me was, plants, said that, you know, race, saying that the insurance left, and I'm like.
That doesn't really bother me. It's not worth it. All right, are we about ready? We keep going. All right, we got 1 more minute. Everybody, we gotta get 12 more minutes.
So.
Ready?
Yes, we're ready.
Okay, I'm gonna start and you may go now.
Lori Smith is the owner and founder of the graphic design forum and wants to include websites. She opposes same-sex marriage because of her religious beliefs. She wants to pose her religious objections to same-sex marriage. Yet, the proposal statement also expressed an intent to deny services based on sexual orientation and actively that the accommodation clause forbids and that the First Amendment does not protect. Thus, the proposed statement itself is not protected in a plaintiff's challenge to communicate clause fail.
Can you tell me what that proposed statement is?
Yes. The proposed statement. The proposed statement is what she wants to post on her website, where basically her claim that she doesn't support same-sex marriage due to her religious beliefs.
And does she have a proposed disclaimer already?
Yes.
We know what that is.
I can prove it.
That's okay, just keep going.
The case of 303 Creative LLC versus firms had a question of compelled speech and associated a duly enacted law, which means like the government must treat its citizens fairly by following law and establish procedure. Also, Smith does not yet offer. Yeah, Smith does not yet offer wedding services of any kind.
Then I'll ask you the same question that I asked your opposing counsel. If wedding services haven't been offered, she hasn't faced any prosecution, she hasn't even taken on a client or refused a client. How is this an issue that is right for judicial review? How is it not a moot point if there's been no harm in it?
Because since it's still a hypothetical situation, what Creative Creative LLC is asking for is to basically overturn the CADA Act. And that's why the here is.
So your position is that if the court were to grant 303 LLC's motion, it would essentially undo Colorado state law, which is in existence to protect them.
Yes,
Is that
it
right?
would undo years of civil rights movement and those who have been. All right.
You're fine.
If the court were to side with creative, it would essentially overturn the Colorado Anti-Discrimination Act, which is something that enforces our 14th Amendment.
So the Colorado Anti-Discrimination Act is Colorado's version of the 14th Amendment, is that our thing?
I believe it's very.
And you believe doing so, or ruling in this way, or making a declaratory relief in this way will undermine Colorado State's constitution and Colorado State's essential, equal protection laws. Get in here or get in. Huh? This is our debate, you're interrupting. This is their time. Either get in or get out. Come on, 2 minutes.
Okay.
Go sit over there, come on. Then in or out, we are in the middle of class, come on. You're interrupting them.
You can't have a cupcake yet.
You cannot have a cupcake yet, no. You can sit over there and be quiet. Please continue, team one, you've been rudely interrupted.
All right, so also with the case, this would be a state, this would be the state bill. This would overturn a kid at law, so it would basically be. So it would overthrow, so it would be, so Mr. Cole's been in our research, that Miss Smith, will be in favor of opening the Pandora's box. Meaning that a lot of is gonna be exploded, I'm sorry. In the case of decide to go inside of her favor. And with the Pandora box, it's basically stating that like, if I was, it's stating my religion is, if I was to say my religion was to stop me from being inactive with things that sin against my religion is totally inaccurate. Like Miss Smith worked with, they said
LGBT.
Yeah, she worked with them, so you can work with them, not only can you can do that, you can also serve like. Or design things for them.
So she has already taken clients that are LGBTQ in other ways.
Yes, in videos with the Alliance Defending Freedom, which is who is defending 303 LLC. Ms. Smith has stated that she has worked with those who identify as LGBT.
In what
Therefore,
capacity?
sorry.
In what capacity?
She did not elaborate, but it's reasonable to assume that it is in a manner that pertains to her business, which means that she has not previously felt compelled to be silent.
So in that state, you say you have work, that will conclude someone to say, if I work with them, you work with them in all types of areas, deal with the business, or in other businesses, or even have relationships with business or not even working.
So your argument is that she's actually not seeking a religious exemption, she is trying to force, or what is your argument? She's not seeking a religious exemption, what is she?
She just based on discriminate that she wants to because of that particular item, like it's not based on her religion in that sense. But if you can work with them, and not only you can work with them, you can also assist in that process.
And last session, this court took up a very similar case also from Colorado, specifically about a bakery who wanted to do the same thing and wanted to deny, and we ruled in the bakery's favor. So how would you distinguish this case and what Ms. Smith is seeking? I sense that we were very prepared for that question. How do we distinguish our ruling in that case from this? How does this any different? Why shouldn't we just automatically rule as we did in the previous case?
So, yeah. So in 2012, Charlie Craig and David Mullins were denied a wedding cake by the Masterpiece Cake Shop in Colorado by its owner Jack Phillips. So at this time, the state actually did not recognize gay marriages as they just didn't recognize marriages. And then also the court did not actually side with Phillips. They actually stated that the court ultimately concluded that the commission's actions, which in this argument would be CADA, they actually violated the state's duty under the First Amendment to not be hostile towards religion or a religious viewpoint as a basis for laws and for regulations. So basically what this is that the court stated that Phillips did not receive neutral treatment based on his religion, and that is why the court sided with him. It did actually not make a statement pertaining to Phillips being able to deny them their wedding cake based on any religious sin.
So the differentiating point is, one, there is now a piece of legislation that exists in Colorado that is not at the time of the original case that we've already ruled on, right? That's point one. And then point two is that in the previous ruling, you're saying that the ruling was limited to specifically that the state had violated the law, not that the defendant, or excuse me, not that the baker was entitled or had to make a cake or was entitled to refuse a cake, just that the state had actually misinterpreted or had misapplied law, and in that it did not apply it in a religiously neutral manner. Is that fair?
Yes, the commission did not apply the law in a neutral manner, and that's why the court sided with them. Additionally,
How would us ruling with you guys be any different then? How would we also not be ruling in a way?
That also the Masterpiece Cake Shop was a limited company, meaning that it was more of a private business, while Ms. Smith's business is an LLC, meaning that it must adhere to state laws. And as previously stated, gay marriage is recognized by the state of Colorado as of 2014.
In that case, I'm 2012.
Yes,
So all those instances and the recognition came at the state level. And then, correct me if I'm wrong, but the recognition then for LGBT and the constitutional right for LGBTQ from Colorado came prior to the federal one, which didn't happen until 2015, would that be correct? Obergefell, the case that made gay marriage constitutional, happened in 2015, quite certain of it. And you're saying Colorado actually enacted law to protect LGBTQ constitutional rights to marry prior to that.
I believe it was.
Knowing that, comparison to California, previously California had ruled similarly, they then retracted it based on voters' decisions and said gay marriage could made it to the court, and our court said that was a violation. How does the fact that Colorado law changed during this affect your argument?
It affects our argument only because Masterpiece Cake Shop, refused to make a cake for a marriage that wasn't even recognized by the state at the time. What Ms. Smith is asking for now is to publicly advertise that she does not, essentially want to work for a marriage that is recognized by the state now.
And talk to me a little bit more about the difference between why Masterpiece and LLC are different. How does that factor into your argument? Can you explain that a little more to me?
The LLC is a public business. There are some differences between what that would entail as opposed to the Masterpiece Cake Shop being an LTD, not an LLC. And it's important to the importance to the case right now is that LTDs are essentially private businesses, while LLCs are not. They adhere to state laws. They have different, I believe, tax regulations and different structures to the way that they run their business. While the LTD is not.
So if Go ahead.
Sorry.
Please do.
So I would like to add that, Florida Smith, since it is a public business, when she chose to make her business public, it's a private distribution. She also chose to adhere to the laws of the state, making sure that she adheres to the code of CADA, which means that she should be able to, didn't have a problem working with members of the LGBTQ community as stated in the past, that she shouldn't have a problem serving them and using their rights as, having a wedding, because she is working for technically the state, and if she had an issue with that, she should make it private instead.
So would your argument then be if the bakery were to bring this injunction, that a different result would be warranted because they are still a private company and not publicly traded as an LLC?
I would say that there would be an issue there eventually where someone can sue. But because she would have more protection under her first amendment right if she was private versus now that she is public. So she is technically working for the state and she technically has to adhere to what laws they have versus if she was a private business.
And what do you make of your opposing counsel's argument that she's being compelled to speak by being told she has to serve and provide wedding website services to a couple that she would, for whatever reason, religious or otherwise, rather not? Go ahead, Jim.
I mean, like, Your Honor, if she feels that way, it means that all of us should feel that way. Just like we have state laws and if we have to abide by the state laws, then it's like, It's like, we have to abide by it, and just in case, through creative, as people else with the case. Yep, and she wanted to consider this expressive, there's gonna be a lot of business. But like. If we start putting up signs saying no jewel served, Christian served, black served, and. We don't wanna go back to that practice again with the Jim Crow.
So
So,
your argument is that we would be opening up a Pandora's box, if she's allowed to go forward, put her disclaimer on the website, we would be opening up or kind of. Letting go of a very slippery slope into what other disclaimers can. A public business be involved in excluding, is that fair?
Yes.
Any further argument at this time from Team Alennis? Yes, go ahead.
That with the Pandora box being open, like Jalen said, it would affect African American people, it would affect people who are non-religious, it would affect people who are, like you brought up the Jews and everything. It would affect those people and it would also affect women's rights. Like it opens that Pandora box to where we can eventually go back in times where their rights are no longer protected. Since the CADA is under the 14th Amendment and that is protected small, then that opens the door really wide to where if we let this pass and it lets Ms. Smith case win, then at that point, it's letting people know like, hey, these can also be overturned.
And let's say we do hold that Colorado is unconstitutional because it conflicts with our definition of the federal. How does that not still protect Colorado state citizens, even if we do overturn or decide to go in favor of 303 LLC? Because we still have the 14th Amendment, and ultimately that's the most supreme law of the land. So how are we really going to be harmed? How are Colorado citizens really going to be harmed if this law is overturned when we already have what you guys are saying is essentially the same thing, the 14th Amendment at the federal level?
CADA is what enforces the 14th Amendment in the state of Colorado.
So it's the agency.
It's an agency that enforces it and ensures that the 14th Amendment is protected throughout Colorado. Essentially by revoking this, you're allowing for a lack of
Respect.
no, you would lack personal accountability. There would be nobody virtually overseeing that businesses in the state of Colorado adhere not only to the 14th Amendment, but to what the Colorado Anti-Discrimination Act is and what that statute covers.
So do you see this as a state's rights issue? And that the state has the ability to make a decision to pursue justice in the way that it sees fit, and this could be further encroachment on the federal side.
Not necessarily because this is like, for example, in the case of the masterpiece cake shop, the two individuals that were seeking a wedding cake brought their case before CADA and then used CADA to sue masterpiece cake shop. So therefore, if you remove this act, you're not.
So she's not affecting just, it's not gonna just affect one group as a whole, it's affecting everyone in society, since it's attacking many different people. If we let one group get attacked, everyone's kind of in the same branch to where they can also get attacked.
Any more this time? You guys have a little less than 11 minutes. All right, time for rebuttal. You guys ready? So I would focus on responding to what I asked questions about. I would focus on responding to what their points were. Whenever you're ready, I'm gonna hit. So. Huh? Yes, you can. Are we ready? Ready. All right, Tucker's ready. Are you guys ready? All right, you have 11 minutes. Do what you will.
Your Honor, as the respondent has stated, she has worked with the LGBTQ individual for meeting that she does not intend to discriminate, but simply won't convey a speech that goes against her belief. In the holy format, we have the right to either speak or not. And in letting Cater remain, we are forcing speech, in which enforcement of speech impedes on the very ground that the First Amendment stands.
Adding to that, as far as compelled speech doctrine, in 1943, the Supreme Court declared as a flag statute case, the flag salute case, that one cannot be compelled to say what they do not believe.
Tell me more about that case. How does that compare to this?
For Lori to exclude, for her to start offering wedding websites and to omit that is a liability for her, because we can refuse later on and then be attacked for that. To be attacked for that, so her stating it is her implementing all of her rights to the full extent.
So are you asking us to overrule CATA in its entirety?
No, there's one clarification that and security that her First Amendment right will not be violated because of the cattle law.
So she's not seeking to overturn CATA. She just wants to specifically have CATA or the court tell her that she is not in violation of CATA before any such violation occurs.
Yes.
All right. And what do you make of the other side's argument that in granting, let's say, and agreeing that she's allowed to put this disclaimer on the website, what does that do for the Pandora's box or the slippery slope argument that any other publicly traded company should be able to do this?
She's not discriminating against those people. She just doesn't agree with announcing their wedding. So, because she believes.
How does announcing a wedding violate her religious beliefs? If she's not saying, she's not being forced to say, I endorse this wedding. She's not being forced to say, I support this wedding. She's not even being forced to say that she believes this wedding is right. She just is told that she cannot put a disclaimer on her website refusing to provide services to a protected class. How does this not fall in the discrimination category then?
She believes her creation is a gift from God and her gift from honor God. So by creating the website, she believes that her creation is her feet. So with her creating the website, whether it's she believes that her First Amendment right of freedom of speech is being violated because the speech is going against her religious belief. A wedding website published by the August to have her name and logo on it, and who wants something published to the public with your name on it if you don't believe that's right?
Very important. What would you make to opposing counsel's argument with respect to the wedding cake? Because typically the wedding cake would be construed very much in her favor, but when we look at the fact that we have two different publicly traded entities, one is publicly traded, meaning that she did choose to subject herself to CATA in opening up her business in the way that she wants to do so, when she could have remained a limited corporation on which we've already ruled and said that she would be fully protected. So why should we grant her this exception when there's already a legal exception for her if she just wants her business to remain private? Why grant the injunction if she could just be a limited corporation instead of an LLC? Wouldn't our case law firmly protect her if that was the case? And then we could have this discussion.
Which is already is protected under the First Amendment.
That's correct, she's protected under the First Amendment. My question is, what do we make about what do you have to say about the argument that if she wanted to continue practicing business in this way, in accordance with Supreme Court law, that has already been decided, specifically with respect to CATA and the ability of Colorado to enforce CATA, which we said it just can't do so in a religiously, it has to do so in a religiously neutral way. Fine, assuming that's been happening, why does she get an exemption as an LLC, but she can't just continue business as an LTD? When we've already ruled that she would be protected as an LTD, but not as an LLC. Because an LLC, as your opposing counsel pointed out, means that you are voluntarily subjecting yourself to the federal and state compliance with all law, whether that's law at the creative level or about speech, or whether that's law on how many employees you can have, or whether that's law on how many bathrooms have to be provided for individuals who are working at your place of employment. So she could have avoided all of that if she just wanted to stay an LTD. It's her idea to propose a business plan and her idea to put the disclaimer out there. Why does she need declaratory injunction if that was her decision to do so? But LGBTQ individuals can't use what is a publicly traded company in accordance with federal law.
Can you speak on why my client has like to go public? But it's not that she doesn't want to desire LGBTQ plus clients. It's just that she does not agree with creating the website for her speech.
Another disadvantage of her having a limited company is that it would result in her paying more taxes and it's more expensive to set up an LLC.
That's fair. So this costs her something financially as well. This is limiting her ability to make money, participate in the free market.
A limited company, but it's a limited options for her business.
And in this sense, that's exactly what she's trying to do, give herself more options. Right? Any more argument? Any more response to what the opposing counsel had to say? Would you agree that you're also asking the court to overrule CATA? Opposing counsel has argued that essentially, if we grant your motion, we would be completely overruling and deciding that CATA is a violation of the Constitution. Would you agree with that assessment? Would you agree that CATA is gutted? How does CATA continue forward after this if we decide the motion in favor? Especially considering the citizens of Colorado voted for this piece of legislation to be passed. Does that not give us some concern that the citizens of Colorado actually don't want us to grant this motion and think that instead the opposite should happen?
I believe my client does not go against CATA for this wanting to be known that it's not discrimination because of their sexuality, but it's because her religion is against marriage of LGBTQ plus. So she doesn't want to overturn CATA for this one, or just want the security that if she doesn't enforce the or she does mention that she will not be creating a website because of the sexual that she's not gay or without messages that contradiction to her faith, and this includes absence marriage, is not because
she wants to discriminate against them, she doesn't want to promote a message that is against her faith.
And risk criminal prosecution. if doing so.
Yes.
And, oh, I had a final question. Slip that. Any further argument? Oh, that's what it is. So in our country, typically, we tend to respect speech at the highest levels, especially when it's in a public place. And in this particular case, we're talking about an internet website, which is definitely going to be very widely publicly available. So typically we respect all versions of speech and we don't like to restrict any versions of speech. How do you see that, the fact that this will be a public website in a publicly traded company coming up against the First Amendment protections both of your client and also the First Amendment speech protections of those that she's making a disclaimer against? How do we reconcile those? Since again, this is a publicly traded space and on a publicly available website. We typically don't like to restrict speech for anybody in those places, either your client or the LGBTQ individuals.
I guess by not disrespecting the clients, but just stating her point of view without any discrimination against the LGBTQ.
Her free speech right is restricted, as long as it doesn't include defamation, fraud, or fighting words and threats. And her statement simply states, I am selective about the messages that I create or promote. While I will serve anyone, I am always careful to avoid communicating ideas or messages or promoting events, products, services, or organizations that are inconsistent with my religious beliefs. In her statement, she does not attack or threaten anyone.
In specifics, at least.
Yes, right.
All right, I'm done. All right. You guys ready?
So this whole time, you guys have been saying the word forcing. Did anyone force her to register her business as an LLC? He deliberately chose to make her business an LLC, which opened up for the government to be able to tell her what she can and can't. If she would have registered as an LTD, then she would have been able to decide what she could and couldn't do. I also think it's important, you guys said that, she, like helped or made like things or I guess her religious belief as, what exactly like, were those things? And if she had already made things, if she makes things already for non-religious beliefs, how does same-sex marriage differ from that? I think it's important to know that to think that her business does not exclusively make it.
So our business isn't solely related to wedding creation or even creation just for the event of a wedding. It applies to many others. And so your argument is not only can she essentially with this disclaimer stop her website from promoting a wedding from LGBTQ, but potentially a birthday party from someone who's LGBT. Would that be fair? So then what do you have to say about, you know, I recognize your argument about the LLC and the LPD is very persuasive. What about the fact that it is her right to enter the free market, expand her business, and do so in a way that doesn't also compromise her religious beliefs? We're supposed to be allowed to participate in the free market. Why should she be limited to only an LTD instead of an LLC when there are much more lucrative options available for her if she opens up her business?
So like when they you guys mentioned about like it's a financial standpoint. He closes the door to be able to make more money if she is only limited to one. Like if it was about the money or the financials, if she would have like took those clients you don't know who they might have known or who would have been there that could potentially have brought more awareness to your business, but you completely cut down that whole idea of essentially making it work.
So your argument is essentially, if I know I'm understanding correctly, since she closes the door on her own financial opportunity by refusing to serve a certain population, you don't need to make an exception or give her an exception to this LLC versus LTD reasoning because she closed it on herself. And what would make sense, right?
First, can you make a question?
The one I just had, AG? Yes, so. To clarify Asia's point, I was asking if what she's saying is what we. That, you know, that Ms. Smith has essentially foreclosed her own financial opportunity. That does not mean that we need to create an exemption under CATA for her LLC to be able to continue to regulate in the way that she wants to when there's already an existing business. One, yes, which does potentially limit her, but she's already limiting herself. So if she's foreclosing the door on herself, why does the law need to open up and recognize an exemption that allows her to go forward in a different way? While ignoring the law that exists.
So. Basically, you're asking if. The court should make an exemption to the law.
Yes, that's what the
But
Smith is asking.
that's what they're, of course, arguing, but at the end of the day, the law must be neutral. One right does not go over another, and that's what CATA enforces, that Ms. Smith's right to religious freedom does not surpass one's right to not have to go on a website and not have to see a statement that reads, I will not be able to create websites for same-sex marriages or any other marriages that is not between one man and one woman. Doing that would compromise my Christian witness and tell a story about marriage that contradicts God's true story of marriage. Not only has Ms. Smith provided her personal interpretation of what the what her Christian values are, but it also discriminates against the LGBT community. It should not be something that should be allowed by the court. You're, like we previously stated, it opens the Pandora box to what religious values can be used to discriminate against people. We've stated that CATA is the result of the 14th Amendment and the civil rights movements. If you recall, a very popular argument against civil rights movements was that religion did not allow for people to, for example, for white people to not have to participate or even have to go with people of color or Black people. So, like I've stated, the law must.
So would this mean then that other publicly traded or public organizations, let's say the church, for instance, do they have to allow weddings or do they have to perform weddings if they are actually the minister because they are a public official and they are publicly a part of or a church, which is obviously not necessarily a government organization, but certainly a tax exempt one that we recognize as having as being a designated public space. Does that mean that we can force churches to do the same?
So in the section. So CATA is section 24-34-601. We do. It does state a place of public accommodation shall not include a church, synagogue, mosque, or a place that is principally used for religious purposes. Ms. Smith has not stated that her business 303 Creative LLC is specifically a business or a religious movement or religious branding or anything like that. On the contrary, she has stated that she has worked with people from all walks of life, including those who identify as LGBTQ community, so I don't see reason why why if she's not identifying as a religious business, why should she be exempt from not discriminating?
So CATA specifically does outline an exemption for people who want to refuse services essentially, but to do, but they have to be affiliated with a particular.
Yes, it's right in the first section, last sentence, and I quote, place of public accommodation shall not include a church, synagogue, mosque, or other place that is principally used for religious purposes. Ms. Smith has not stated that her business is used only for religious purposes.
She has stated that she believes that her business is an expression though of a God-given talent. What do you make of that argument? How would you respond to that? James, please go ahead.
If I may, go to evidence 14. If it is a God-given talent, then she should treat it as a God-given talent. So earlier, when she stated that in Romans, they talked about these people as well. Also, inside of the same scripture of Matthews, it says, "Do not judge, for you will be judged too. For the same way you judge others, you will be judged. And the measure you see it will also measure for you." So, by you declining service because you said it's sinful and it's against your religious belief, nowhere inside the Bible states it that specifically about homosexuality. It is basically it talks about how they want you to be like a man or woman, but it doesn't say that I have to deny service. It does not say that if I associate with them or do partnership and business with them, I will go to HELL because I did that. So
Is she not entitled to her own interpretation of her religious beliefs?
she can be entitled, but when you try to use it for the law and also trying to make it justifiable and still deny someone out of discrimination, you can't, because you are all on the same type. So with the CATA, what it does, if you let one slide, then you have to let other slide. And if you don't let other slide, that's going against your whole entire 14th Amendment of why you're doing it in the first place.
So with that said, any left, yeah, Katie.
Can I also note how they said, that the First Amendment didn't protect ideals or anything? And we say in a way, our words on your website are fighting words when it comes to, civil rights, because she is going against some whole, data that protects random people.
So your argument is that she's not protected at all, because this is falling under hate, discrimination, or other kinds of fighting for speech. She's not protected by the First Amendment. That her disclaimer is not that her religious beliefs are, but her disclaimer on the website would not be protected as speech. Right? Any other argument? Yeah, 15 seconds.
The opposition.
Press.
Yeah. Round of applause. Yeah, I know you guys are like in full panic mode because you don't understand the question process, but that is 100% what a Supreme Court argument looks like. I am particularly impressed with the LLC LTD. I was not gonna give you guys business law. I was not even gonna go there. You found it on your own. Particularly impressed with that. Particularly impressed with the fact that we're talking about compelling speech, because it's not just that she has a First Amendment right to religion. We're talking about actively making someone do something or create something. That's where you guys are really getting a good stride, is if you're asking someone to actually create something, you're telling them they have to speak when they don't want to. And we don't do that in this country. That is absolutely the best, like, hang on, I think you guys went with, in addition to the fact that this does limit her financial opportunities. And in this country, although she has the LTD option, we don't force people to do that. We don't force people to play business in a way that they don't want to. We let them do business in the way, in fact, the Commerce Clause, so other areas of constitutional law that we do not cover because it's very boring, it's very dry. I don't know how you guys found LLC and LLC, but anyway, if we had gone into Commerce Clause like that, fully is protected. So banking on that and saying like, no, she's still allowed to participate in financial opportunities and not be forced to speak is is absolutely, I think, the right way that you guys went. I think bringing up the LLC and the LTDs, you made a great point. I also think you guys did a really good job distinguishing that case. If you had not known that case, I definitely would have not docked you points, but it would have been a big problem, because like that's obviously a case that's referenced in the material. And I think you guys did a really good job distinguishing that. And I also thought you did a really good job, Jayla, that last point that you made, is we're gonna parse through religious. Ultimately, the court's gonna see that you're wrong because they're right. You have your own interpretation of religious abilities, but as far as being persuasive, that's a hell of a persuasive argument to make. Hey, if you're gonna say that this is about speech and interpretation of your religious beliefs, here's what your religious beliefs say. You can, they literally contradict the disclaimer you want to use. So I think that was persuasive. It's not necessarily the best legal argument, but it was persuasive. So when I said on the, you know, obviously I wanted to use case law, you talk about LTD, talk about the previous case, talk about the case law that existed that you brought up with respect to, this case name that started with an H. No, yes, the Harvey case. That was a great thing to do, but it's also always great to add in those tiny persuasive things that like just push you over the edge a little bit, because those are gonna be the things that, those are the things that really make the decision. We have to rest on them legally, yes, but when you guys are being persuasive like that, that also matters. Those are also things the court's gonna take into context about what's happening. So I think you all did an excellent job. I'm very, very impressed with what you were able to put together. That's it, you're all done. Except for, don't forget, you have to finalize or give me your proof evaluation of each other and your reaction to how you think this case is actually gonna go down in the Supreme Court, given who you know is currently on it. And also, some recent decisions have been made and they've been shockingly liberal, so just kind of make sure you contextualize that. So any questions for me? Yes, Dylan.
What's the page requirements again?
I believe your evaluation is 1 page and your reflection is 1 to 2 pages.
Questions on the case.
Yes, reflection over this case. Any other questions? That is all due on May 4th.
You know, honestly, I actually thought that this side could win, but after listening to the and the rebuttal, it's